All right. Chapter 23 is about corporations. So again, 21, 22, or 20, 21, 22, 23, those four are all about forms of business, right? So again, there's the things they want you to learn about. And so just a little historical background on corporations. So the concept of corporation, which is the concept of splitting a business up into owners that are protected from liability and managers who might have some liability, that's been around since forever. Like, I don't know when. I don't know if it's like a Garden of Eden thing. Maybe. I'm guessing it's post-Eden, I'm guessing, actually, because I don't think people in the Garden of Eden were that concerned about liability. Maybe though. Anyway, but it predates recorded history. So when the first written code of laws that we've ever known, right, the Code of Hammurabi, written on cuneiform tablets, it had language about corporation law. So from that early, so meaning it existed earlier, right? People wanted to be able to say, I have a business and I should be able to sell off parts of the business, and certain owners of that business, the people who are just providing capital to me, shouldn't be fully liable for all the things the business does because they're just kind of silent investors. So that concept existed a long, long time. So it became more formalized. Anybody watch like Pirates of the Caribbean? Anybody? So remember like the East India Company, they had all this power, right? Well, they were actually given power by the government of Great Britain to run these business interests and in essence govern the areas where their business interests were at hand, and they became these huge, powerful companies. They had the power to wage warlike scenarios, fight against, say, ships that attacked them on the high seas, and they were even given letters of marque, which gave them, in essence, the authority to be pirates. They could pirate other ships flying the flags of other nations. And this was all given by special dispensation of the government, saying we're imbuing this private company with certain governmental type powers. And so it was done in a very special, one-on-one decision of the legislature to decide should this company be given these kind of powers. Russia did it even earlier than Britain, and there's more. I just didn't want to list them all. So at the time of the revolution in the United States, you're talking 1780s, right? I think the book says by 1790 there were a handful of corporations that had received specific authority from the state legislatures. And by, say, 20 years after that, there were hundreds of corporations. So it really proliferated. And to the point where legislation started just being written that would kind of allow people who would go through a certain set of things by matter of course to become corporations and have certain authority. As of right now, only about 25 states have adopted the model legislation for corporate law, so half, meaning the other half are doing their own thing. But I'll tell you that it's pretty similar in most states. Anyway, so that's the historical background. All right, so the way the textbook broke it down is to separate this out and just compare it to partnerships. So from a formation standpoint, partnerships are easy. You do some business together with another person, your partners. Maybe it'd be nice to write up a document, like a contract between the partners as to who has what job and how much they'll be compensated and so forth, but not even required by law. You could just do business together. Where a corporation is complex, and I would suggest hiring attorneys if you want to start a corporation. Pay them to do it right. It's worth it. Okay? In a partnership, the general partners have control. In the corporation, managers who are hired by the board of directors have control. And the board of directors are elected by whom? What would you guess? The shareholders, right? So the shareholders elect a board of directors, and then the board of directors hire the boss and the CEO, and then the CEO makes the decisions for the company. Okay? And I put a note here that says this is less pronounced in closely held corporations. So my mother owned a corporation where the shareholders were her and her parents, And then the elected board of the corporation was my mother, me, my uncle, right? So this whole issue of ownership and control in a closely held corporation, in that case, the shareholders still maintain pretty much all the control. Okay. Then it started to look a lot more like an LLC or like a general partnership scenario, or limited partnership. Transferability of interest, that means how do the owners sell their share of ownership in it? With a partnership, all the partners must consent. This is one of the big pluses of corporate incorporation. In a corporation, I could sell my share of ownership freely. I don't need anybody's consent. If I have some shares of Microsoft stock and I decide I don't want them, I can just sell them back to the market to the highest bidder, or I could find a friend and sell them to him for whatever he's willing to pay me. I don't need any consent from anybody. And this is why, which isn't really covered in this chapter, but this is why things like hostile takeovers can happen with a corporation. Anybody know what a hostile takeover is? What? Mm-hmm. Correct. So a lot of times, the person who comes up with the idea and starts the company, at some point, they need more capital. So to raise capital, what they do is they sell off shares of ownership in the company. Well, if they sell off more than half, which they often do, they'll sell like 70% of it. Well, that means technically, if somebody were to buy up more than what they own and more than what their friends own, they could have control of the company. And so what happens is there's certain laws that depending on the size of the company and if it's publicly traded or not, that require notification of all the stockholders if a person owns more than a certain amount of the company. And that's usually something around 30 to 35% of the company. Depends on the states, it's a little different. Although the SEC rules are the same everywhere. I just don't know the number off the top of my head. But it's in the 30 to 35% range. So in essence, what someone will do is they will buy quietly. They won't usually buy it in big chunks because that would draw attention. They'll buy little bits of the company here and there till they get right up to that threshold where they're going to have to report. Then they'll do what's called a tender offer. They'll go out to all the rest of the shareholders and say, hey, right now, this company's stock is trading at $35 a share on the Wall Street markets. We'll offer a premium of 10% on that, so $38.50 a share to anybody who will sell it to us now. And if they're successful at that, all these people go to the market, sell their shares to them, they pay a little premium, but suddenly they own 52, 53% of the company. They go in the next day, all the board of directors get a phone call that says, you're no longer on the board of directors. We've elected these people on the board of directors, which means the CEO then gets a pink slip that says, you're no longer the CEO, new management's in town. They hire a new CEO, and then usually the upper levels of management start dropping like flies too, right? Now remember, most of those CEOs and the upper level, the vice presidents of the corporation, they're also shareholders. So they're still holding on to their shares, or maybe they're the ones that sold them out to the new company, because that does happen too sometimes, where they'll keep some of the upper management that were kind of on their side, right? Anyway, so that can happen with a corporation because transferability of interest is such a simple thing. So it's an advantage in the sense that it makes it very easy, but it can be a disadvantage in the sense that you could potentially lose something that you built over your whole life if you're not careful with the amount of ownership stake you have and not careful. This happens in companies where maybe a bunch of the shareholders feel like the direction management is going is not good for the company. So in essence, they rise up. Because that can happen too without a buyout. If you can get a guy who's a significant shareholder to say, hey, join with me, let's get rid of this board and put new leadership in, that can happen too. Okay. Corporation or partnerships, the partners share in the profits and losses, and then the general partners sometimes get a bigger amount depending on the partnership agreement. Corporation, the shareholders share in the profits and losses. So that's very similar. Then the taxation is the other biggie. For a partnership, they have pass-through taxation like we talked about, where the profit or loss is kind of just reported to you on a statement that goes on your personal taxes. You're good. Whereas corporations have what's called double taxation, meaning the corporation files its own corporate tax return and pays taxes on it. And then the shareholders are also taxed on any dividends they receive. But it's only on dividends they receive. So it's not a completely bad thing. Like some corporations don't pay much dividends. Some don't pay any at all because they're reinvesting all the money back in, and the stockholders are really just trying to make money on the growth of the company, not the dividends. At which point they wouldn't pay any individual taxes because it's not paid out any dividends to them. So it's not completely like a bad thing, the double taxation. It's just different and has different limitations. All right. So court law has recognized that the corporation is a person, but not, quote, a natural person. So what they've said is that in essence, though it is a person for many treatments in the law, it's not fully protected in all ways, the same as an individual would be. Corporation still has free speech, still has a right to due process. If there's going to be action taken against it, the government has to go through that. Has protection from illegal searches and seizures, has protection from double jeopardy. They can't try a corporation in court, and then if they don't win the case, the government can't bring the case against them again. So the big notable difference is that this right against self-incrimination, that natural persons, meaning individuals like you or me, that we have, a corporation doesn't have. And I think the reason they don't have it, this is my opinion, my legal opinion, even though I'm not a lawyer. I'm smarter than most lawyers, though, so that's good. It's a joke, kind of. All right. Ask my lawyer friends if I'm smarter than them. They'll probably tell you no. A corporation, because it represents so many shareholders and people, and because it has a specific stated purpose for existence, that's in its corporate charter, which is part of that complex process of creating the corporation. If there is information of fraud or wrongdoing, the corporation is required to turn that information over to investigators. Whereas you as an individual, you as a natural person, you don't have to incriminate yourself. If they ask you questions, you can say, I'm not going to answer that question. Right? So it's slightly different. Even though, honestly, what's interesting is you don't have to turn over, say, like personally important papers to the cops doing an investigation on you, but if you destroy those papers, you're breaking the law. Now that's destruction of evidence. But if you hid them a long time ago, before you were being investigated, and then they just couldn't find them, you didn't do anything wrong. You don't have to say, hey, okay, they're hidden over here, right? Whereas a corporation would have to say, there is information that incriminates the corporation. And it benefits the individuals involved in managing the corporation to do that, because usually their sentencing would be lower if they cooperate fully with investigators. So that's one of the big differences, the self-incrimination issue. One other concept that they talk about, you'll hear like in court dramas about businesses, is this concept of what's called the corporate veil. And sometimes they use the term piercing the corporate veil. So when they say corporate veil, if you ever heard that on a TV show, or maybe if you go into a career where you're working with these things, the corporate veil means that protection that separates shareholders from the decision-making side of the company, and therefore protects the shareholders from liability. So they can lose their limited liability, meaning the shareholders can, in a couple of instances. And both of these really apply to smaller corporations or closely held corporations. It's much harder in a giant corporation where there's millions of shareholders who really honestly have no idea what management's doing. But if it's like my mom's corporation where there's really 2 shareholders, okay, then number one, if one of those shareholders commits fraud, for example, there's a case in the book where someone burns down a building that belongs to the corporation, and the insurance company is supposed to make payment to them for the loss of the building. But then they find out it was one of the shareholders who burnt down the building. You can't benefit from wrongdoing of yourself, right? Like, that's not okay. So in a closely held company, closely held corporation, shareholders cannot benefit from the fraudulent actions of a shareholder. You can't burn down the place, then they pay the insurance. Whereas in a big corporation, if, say, one of the shareholders burnt down the building and resulted in the loss of an asset to all of these other thousands of shareholders, the insurance company would probably still have to pay the corporation. Okay, and then the corporation would be made whole on that. Now, that one individual would be subject to criminal penalties for arson and for maybe fraudulently filing a claim. So there's a difference. When you're in a smaller company, it's much easier to sort of pierce that corporate veil and act in ways that might create liability to you. Okay. The other is failure to act as a corporation. This is the most common reason why small corporations end up getting stuck with liability on something. It's because they said they were a corporation so they could have the limited liability, but then they didn't actually do the things that corporations are supposed to do. So in other words, if you're just saying you're a corporation, but you're acting like a sole proprietor or acting like a partnership, then in essence, the law is going to say, hey, you're a partnership. And so your limited liability is done away with. So things like inadequate capitalization, like the shareholders became shareholders, but none of them actually paid into the company. Okay, that means you're not really a corporation. Or omission of regular meetings. Remember I said there's these complex rules about being a corporation? Well, one is that you have regular corporate meetings. And at those meetings, you record minutes of the meetings. And you actually are transacting appropriate things as to what's supposed to be done at those meetings. If you're not doing any of that, then the law says you're not really a corporation. And you're not really entitled to the special protection of being a corporation. Commingling of personal and corporate assets. This is the biggie that gets most people. With my partnership, if I take money from the partnership and I record that so it shows that I'm taking a distribution from the partnership, no problem. In a corporation, if you start taking money, that's theft or embezzlement. If you start living in a house that's owned by the corporation so that you don't have to pay taxes on it, but the corporation does, that's called commingling of assets. And pretty soon, again, the government says, this is more like a proprietorship. This is more like your assets and the business assets are all the same. So you can't really get the limited liability if you're not keeping it separate. Okay, so these are the biggies. And the most common, or the ones I put there, is bullet points. Because of the way corporations are, it's often that the managers of the corporation are also shareholders of the corporation, right? Often a big chunk of like CEO's compensation comes in the form of options to buy stock in the company at some fixed price. So a shareholder who's acting in a management capacity can still be subject to personal liability if he's acting beyond the scope of his or her authority. Okay, so if they're really just doing their regular job and running the company and then the company gets sued, they're not personally liable. If they're acting outside of their job and like transacting business or doing things with other individuals or companies that they shouldn't be, even if they're not illegal, but they're acting outside of their authority, then they could be subject to personal liability not only from the shareholders, well, say not only from the outside entity, but also from the shareholders. But that's because you have a fiduciary duty. When you're in this sort of a management capacity, you have a duty to not transact business outside of the best interests of the business. And then the other, whoops, I think that's not supposed to be on there. That's from the last one. So actually, that's the end of that one. That's all we're going to learn about corporations. And that's it. Where are we at on time? Did we do okay? Perfect. All right, so if you haven't yet done the pre-read stuff for this chapter, get it in. I would suggest that each of you take a look at your grade in web study, make sure that there's not things that you thought you'd done but you'd missed, and if you're afraid to look at your grade because you know you haven't done some stuff, really take a look at your grade and address those issues. Have a great day.